This is an AZCourtHelp Legal Talk on changing parenting time.
My name is Steve Wolfson. I'm an attorney at Dickinson Wright here in Phoenix. When we talk about changing legal decision making or parenting time orders, so there is no custody, there is no terminology known as custody in Arizona family law anymore. All of custody is broken up into two buckets, if you will. One is legal decision making, and the other bucket is parenting time. So, legal decision making is, as it sounds, the process of making legal decisions for your child or children in all major areas of his or her life, such as educational decisions, medical, mental health decisions, and sometimes may involve social activities, um, or other major decisions that come up, to a lesser extent, religious decisions. But those are all within legal decision making. What school will the child attend, public versus private? What doctor or dentist will the child be seen or treated by? Whether the child will have mental health treatment, counseling. Those are all major decisions that come within legal decision making. Then everything else is within parenting time, summer parenting time, holiday parenting time, the parenting time schedule during the school year. How are the exchanges going to happen between the parents? Everything else that doesn't involve a major decision, like I just described, education, healthcare, social activities, everything else then is in that other parenting time bucket. And that becomes more important as we talk about the process of how the court will look at changing those orders with regards to either legal decision making or parenting time. The court looks at those differently. So that's why it's important, if you have an issue about legal decision making, you make that very clear to the court. But if it's an issue with regards to a schedule or how the holidays are allocated, uh, then you also have to make it clear to the court that you're focusing in on a parenting time issue versus a legal decision making issue. So once we have that clear, um, then we look at what kind of considerations will the court look at when it's looking at a request to modify or change an order, either for legal decision making or parenting time. And the first statute that you need to look at is Arizona Revised Statute, ARS 25 403. Go to azledge.gov to find a copy, but ARS 25 403 is the statute that includes all the factors that the court would consider when looking at modifying either a legal decision making issue or a parenting time issue. So, for example, if you were looking at 25 403, you would see factors such as the mental and physical health of the parties. You would see a factor concerning which parent is more likely to allow the child or children frequent, meaningful, and continuing contact with the other parent, whether the child is of suitable age and majority to provide an opinion about legal decision making or parenting time. All those types of considerations are found within 25 403. So often when you look at that statute, you'll see the particular area that, or the particular topic that is an issue in your situation, and you want to make reference to that. So you want to say, for example, we have a parenting time dispute and the other parent, whether it's mother or father, is not allowing access to the child, either access in general or access that's already provided for in an order. And I've asked that other parent to cooperate. That other parent has refused to cooperate, and that's why we now have the issue that the court, that requires us to request the assistance of the court. So that's a specific reference to 25-403A6, because one parent is not cooperating with allowing the other parent frequent, meaningful, and continuing access to the child. So that's just one example. You may have a case where a parent is not keeping up with their treatment. Maybe they have a depression diagnosis. Maybe they have a high anxiety diagnosis. Maybe there's a bipolar issue. If that parent then has a diagnosis, they likely have treatment that they're supposed to follow, and he or she is likely to also have medication that they're supposed to be on. Well, if a parent is not doing that, and that's causing issues, either causing issues with legal decision making, or not complying with a parenting time schedule, then you'd also want to refer to the factor that the mental health of this parent is an issue, and that I'm citing to the court 25-403 and asking for the court to take a look at that issue in particular. So 25-403 can kind of be a roadmap to help you craft and create your request to the court. Now, 25-403 also has a lot of subparts to it. So in particular, there are subparts that address domestic violence. There are subparts that address substance abuse, and there's a subpart that addresses sexual offenses, convictions that involve sexual crimes. So you need to look at those subparts. 25-403.003 is the domestic violence and child abuse subpart. So you would want to take a look at that particular subpart if that's the issue in your situation. You're concerned about corporal punishment, or you're concerned about other abuse issues that might be occurring. You want to look at that subpart to get some idea for what the court needs to look at. The same with 25-403.04, that concerns substance abuse. So if substance abuse is an issue in your case, where a parent is abusing alcohol, abusing medication, or having other substance abuse issues that affect their ability to either make or participate in major decisions for your child or children, or to exercise and care for the children during the parenting time schedule, you're going to want to look at 25-403.04 in particular, and then cite that to the court. And when I say cite, I mean you want to list that out as part of your request to the court. There are many counties throughout Arizona that have forms to use as a template for a request to modify orders. Maricopa County is one county that has a self-service center, and also forms that can be used and tailored to a particular situation and a particular request to the court. I think Pima County also has a self-service site. If your county doesn't have forms available to look at, you can look at the Maricopa County Self-Service Center, and download some of those forms or use them as a guide to create your particular request to the court. In general, the more specific you can be with your request, the more likely it is that the judge assigned to your case, will be able to understand the request and then schedule an appropriate meeting for examining the situation, whether it needs to be accelerated, whether it's an actual emergency, or whether it's something that can happen in the regular course of the court's calendar. So 25403 is a place to begin. I mentioned earlier that often the court will treat legal decision-making issues, again, those major decisions and disputes regarding legal decision-making, different than disputes with regards to parenting time. And one place that the court does that, draws a distinction, is in a separate statute, 25-411, and that statute is specifically for requests to modify orders that have already been put in place by the court. So let's say that there was a divorce in 2018, and there was a parenting plan that was ordered by the court, and now in 2023, issues have come up. You need to look at 25-411 as well. And one of the reasons why you need to look at that statute is because there are different time periods associated with different types of requests and different issues. So let me give you an example. In general, courts do not permit parents to request changes to orders on a monthly or semi-monthly or on a regular basis. The reason for that generally is that upheaval or too many changes for children are not healthy, and can be destabilizing to the family, and the court simply does not have the resources. Most courts throughout the state simply don't have the resources to look at cases on a regular basis. So as a result, the court says in general, you cannot make a request to modify either legal decision-making or parenting time sooner than 1 year after the order was entered. So that's where we start. Has a year gone by? And if a year hasn't gone by, but there's still a good reason to ask the court to look at this situation, whether it's legal decision-making or parenting time, then you have to look at whether there's an exception that applies. So by that I mean the court can look at the request sooner if it involves, and this is why it's important to be specific with the court, if the request involves an issue that affects the health or safety or general welfare of the child or children, then the court has the ability and the discretion to look at the situation sooner. So specifically, the language is the court shall not look at a motion to modify legal decision-making or parenting time earlier than 1 year after the date of the order, unless the court permits it to be made on the basis of affidavits that there's a reason to believe the child's present environment may seriously endanger the child's physical, mental, moral, or emotional health. So that means that there's something going on that is not run-of-the-mill, is not something that can be handled later, but is something that's pressing, and something that requires the court to get involved sooner rather than later. And that's why, A, it's important to be very specific in your request to the court, and B, if you're going to claim that this part of 25-411 applies, then you need to specifically describe enough to the court that the court is going to agree with you that this is something that needs to be looked at now, whether there's been some sort of physical abuse, or whether there's been mental abuse, or whether there's been some other situation. Maybe there's been a crime committed. Maybe the police or the sheriff's office has been involved. You need to specifically describe what has occurred, the dates of when something occurred, and provide the court enough specific information that you're going to persuade the court that this needs to be looked at now versus later on. So, first of all, no request for a modification in general sooner than 1 year. Second of all, you can ask the court to allow a request for modification if that year hasn't gone by yet. If you give the court specific information about why the child or children's physical, mental, emotional, or moral health is in danger. And if you don't quite have that, but the situation involved, as I described a little while ago, a case where a parent is violating orders of the court, either violating a legal decision-making order or violating a parenting time order. Maybe the parent is trying to enroll the child in a school that's not agreed upon. Maybe the parent is trying to take the child to a new doctor that's not agreed upon. That would be a legal decision-making issue and a violation potentially of the existing order. Or maybe the parent is violating the parenting time schedule by not returning the child or children at a particular time. If there are examples that you can provide the court of the parent violating the existing order, then you can make that request within 6 months of that original order. So I know it's hard to follow, but you have a year, then you have 6 months, and then you have a much more immediate request if you can show the court that there are issues that need to be addressed immediately or sooner rather than later because of the danger to the child's physical, mental, moral, or emotional health. So you need to keep those things in mind. And in general, what I'm referring to here are situations where you and the other parent share joint legal decision-making. Because under joint legal decision-making, there's going to be a requirement that both parents be involved in those major decisions that I described before. Selection of a school, what physician, dentist, counselor the child is going to see. Those are the types of major decisions that within joint legal decision-making, the parents need to communicate together about and make those decisions together. If one parent is trying or insisting on unilaterally making those types of decisions for the children, that's likely a violation of the existing order of the court for joint legal decision making. So if there's sole legal decision making, that's a different situation, and there wouldn't necessarily be the same violations or lack of compliance with the order that I was just describing. So when you make a request to the court, it's important not only to be specific and give as many details as possible, dates, places, times when certain things occurred, but it's also helpful to give the court and attach information if you can. So, for example, if the police or the sheriff's office had been involved, you would want to get a copy of that departmental report, often referred to as a DR, and attach the report to your request to the court. If the issue involves lack of compliance with the joint legal decision-making order, many judges would like to see that the one parent made an effort to communicate and the other parent either ignored it or didn't reciprocate. So how do you do that? You would want to attach email messages sent. And why do I specifically refer to email? Text, even though it's widely used, is very hard for the court and even most attorneys to follow. Who's in blue? Who's in green? When did the text occur? Many text chains and exchanges are not dated or time stamped, and so I strongly encourage any parents who are viewing now to primarily use email for any communication having to do with the major decisions for the children. You send an email. I think our son should go to this school. Here's the dates for enrollment. What do you think? And then when you get the response, or if several emails are sent and there is no response, you can attach those and the court can much more easily see the chain of communication than they ever can with text messages. So that's just one example of the type of information that would be helpful for the court to see in addition to your description of what's occurred or what hasn't occurred. The court, and as a judge pro tem, which is a substitute judge essentially, over the past 30 years, I've reviewed many requests for modification, and judges do their best to take the information submitted by parents at face value. But if there's, vague or unclear statements, allegations, it's hard to decipher essentially who's giving the best description or who's telling the truth. So often judges will discount, maybe up to 50% of what they read from one parent versus what they read from the other parent. So to the extent that you can, again, be specific with dates, places, persons involved, the names of persons involved, who are they in relation to the children, and then B, to attach information, if it's available, actual records, whether they're school records or law enforcement records or records of communication, as I described. It helps the court gain greater confidence in the information that they're reading, and it gives greater credibility to your statements to the court. And then ultimately, depending on the court's calendar, judges will set hearings on the request for modification where it will actually consider evidence, which can be documents or testimony, whether it's from the parents or from witnesses, to determine whether the request for modification of legal decision-making or parenting time is justified and should be granted. So in general, there is a process for requesting modification and changes to legal decision-making and parenting time orders. And those requests need to be in writing to the judge assigned to your case. Those requests, as I've said several times already, just to emphasize, need to be as specific as possible And to the extent that you can refer to parts of the statutes that we've talked about today, 25403 or 25411, it can be very helpful to your case. And then the documentation can also be helpful in giving your request greater credibility. And to the extent that your request is more credible to the judge, it's going to be more persuasive to the judge. And ultimately, the judge, he or she, cannot change the orders until they've had an evidentiary hearing. An evidentiary hearing, again, is a hearing where there's the ability for the parents to address the court, provide testimony or other information, whether it's in the form of documents or in the form of witness testimony, so that the court has the most complete set of information in front of it before it decides whether to modify the existing orders, and if so, how is it going to modify the existing set of orders. Ultimately, every judge has to make decisions for the children in the case that are in their best interest. The court is vested with very broad discretion to decide what is in the children's best interest or not in their best interest. And so the more information you can provide, the better, and the more persuasive you're going to be.